Episode 10, Beneficiaries. Hello, my name is Alexander von der Velde, and welcome to Trusts Unpacked, where we strip away myth and marketing and explain in plain terms how trusts actually work in real family situations. For the last 20 years, my fiduciary work has focused almost entirely on the architecture of trusts, the skill of trusteeship, and the challenge of long-term family governance. Not as a technical exercise, but as a human one. In doing so, I've advised hundreds of families, as well as institutions and advisors across the world. Alongside this advisory work, I'm also a published author. Last year, I completed a trilogy that reflects both the technical and the human dimensions of both the fiduciary and private banking fields. Now, before we begin, a brief but important note. This podcast is provided for general information and discussion only. It does not constitute legal, tax, fiduciary, or professional advice, and it should not be relied upon as such. As ever, you should always seek advice from appropriately qualified professionals in your relevant jurisdiction before making decisions or taking action. So let's start. Today, in this last episode of the group dealing with the human roles within the trust, we turn to the group around whom most trust disputes ultimately revolve, the beneficiaries. And we look at right, benefit, and misunderstandings. Trusts are created for their benefit, and yet misunderstandings about beneficiary rights are one of the most common causes of friction, resentment, and outright dispute in trust administration. This session is about bringing a bit of clarity to the subject, what beneficiaries are entitled to, what they are not, and how their expectations, rather than law, often destabilize otherwise sound trust. So, who is a beneficiary in legal terms? I know I've always said I don't want to get into legalese in this podcast. However, we've got to begin with a legal foundation. A beneficiary is not simply someone who hopes to receive something. A beneficiary is someone who falls within the defined objects of the trust. And again, that definition matters more than most people realize. In fixed trusts, beneficiaries have defined, enforceable interests. In discretionary trusts, beneficiaries do not. That is what makes discretionary trusts so powerful and so open to tension. Beneficiaries have rights of consideration, not rights of entitlement. This distinction is central, and it is widely misunderstood. Being named as a beneficiary does not mean owning trust assets. It does not mean control, and it definitely does not guarantee distributions. What it means is expectation and the authority to insist that trustees act within their powers, comply with their duties, and administer the trust properly. That is a powerful right. But it is not a right to outcomes. Now, many beneficiaries struggle with this distinction because it runs counter to everyday experience. In most areas of life, being a beneficiary implies receipt. In trust law, it implies eligibility, not ownership. That's deliberate. Trust law separates benefit from control precisely to allow judgment to operate. Now let's look at the different types of beneficiaries. Because not all beneficiaries stand in the same position, understanding this helps to explain why tensions arise. So let's look at the two main types. Firstly, fixed interest beneficiaries. In a fixed or life interest trust, certain beneficiaries have defined rights. For example, a right to income or a right to capital at a future date. These rights are clear and enforceable. Disputes in fixed interest trusts therefore tend to focus on valuation, investment policy, or fairness between income and capital. Now, discretionary beneficiaries. In discretionary trusts, beneficiaries have no automatic right to anything. They're entitled to be considered, nothing more. This is often difficult to accept, particularly where distributions have been made regularly in the past or the trust is perceived as family money. But the law is clear. Past generosity does not create future entitlement. Let's now look at contingent and future beneficiaries. Many beneficiaries are contingent, i.e., their eligibility depends on a specific set of circumstances. They may benefit only if certain events occur or other beneficiaries cease to qualify. These beneficiaries often feel invisible, yet their existence matters greatly to trustees, who must consider the interests of the class as a whole, including those not yet born. This is often where trustees' decisions feel opaque to current beneficiaries, but they are acting correctly. It's also important to recognize that beneficiary status is not static. A beneficiary's legal position may remain unchanged, but their perception of that position evolves over time. A child beneficiary may initially see the trust as something distant and abstract. An adolescent beneficiary may see it as a promise. An adult beneficiary may see it as a safety net. And a struggling beneficiary may see it as an obligation owed. Now, none of these perceptions are legally relevant, but all of them are behaviorally powerful. But trust law doesn't adjust rights based on need or frustration. Trustees must operate in a world where perception drives reaction. This is why trustees who understand the developmental arc of beneficiaries tend to perform better than those who focus only on legal status. A trust that works well for a family with young beneficiaries may struggle as those beneficiaries age and expectations crystallize. The structure has not changed, but the psychology has, and ignoring the shift is one of the most common causes of friction in long-running trusts. So what are the core beneficiary rights? Beneficiaries do have real, enforceable rights. These rights exist to ensure accountability, not to provide leverage over trustees. So these core rights include the right to proper administration. Beneficiaries are entitled to have the trust administered in accordance with the trust deed and in accordance with fiduciary law. That's the foundation of all beneficiary rights. They have the right to proper consideration. In discretionary trusts, beneficiaries are entitled to be considered properly. That means trustees must turn their minds to the beneficiary, consider relevant factors, and disregard irrelevant ones. It does not mean that trustees must agree with the beneficiary's request. There is also a crucial distinction between rights that exist and rights that are exercised. Many beneficiaries possess rights they never use. Others attempt to exercise rights that do not exist. The right to enforce proper administration, for example, is powerful, but is also blunt. Once invoked formally, it changes the tone of the relationship permanently. Trustees become defensive, advisors become cautious, communication narrows. And that's why experienced beneficiaries, often advised by counsel, are selective about when to escalate. By contrast, beneficiaries who misunderstand their position may escalate far too early, often out of frustration rather than strategy. The result is usually counterproductive. Trustees do not become more generous under pressure. They actually become more procedural. Understanding this dynamic helps explain why some beneficiaries feel that asserting rights leads to worse outcomes. It's not retaliation, it's risk management. The third right is the right to enforce the trust. If trustees fail in their duties, beneficiaries may apply to the courts. This is a serious right, and one that courts treat carefully. Litigation is a last resort, but its availability underpins trustee accountability. The fourth right is the right to information, but within limits. The right to information is one of the most misunderstood areas of trust law. Beneficiaries are generally entitled to know that the trust exists, understand its general nature, and know how trustees are administering it at a high level. But they're not entitled to trustees' deliberations, legal advice, or confidential material. The balance is intentional. Too much disclosure paralyzes decision-making, and too little disclosure breeds suspicion. And good trustees manage this boundary carefully. I want to illustrate how beneficiaries experience trusteeship, not through documents, but through judgment exercised over time. And again, this is an example from my book Trust. Some years ago, I worked with a young American actress whose career was beginning to accelerate. She wasn't reckless, not entitled, not naive, but she was entering an industry that rewards speed, noise, and short-term wins. And she was about to become a beneficiary of a trust designed to protect her income, her intellectual property, and, indirectly, her future self. From the outset, the temptation was to build a structure that could respond quickly. Large distributions when income surged, flexible access when roles paused, a system that mirrored the volatility of her earnings. On paper, this would have looked generous. In practice, it would have taught entirely the wrong lessons. Instead, I made a deliberate choice. The trust would smooth income rather than amplify it. It would respond consistently rather than generously, and it would never react emotionally to success or fear. From her perspective as beneficiary, this mattered. When her first significant contract landed, she didn't suddenly receive a windfall. Funds flowed into the trust. Living expenses continued to be met at the same level as before. There was no reward for noise, but also no penalty for silence. At first, she questioned it, not angrily, but with curiosity. Was this restraint necessary? And that question was exactly the point. Because over time, the trust taught her something subtle. Her worth was not measured by her last role. Her security did not depend on saying yes quickly. She could afford to pause. And because she could pause, she made better career choices. Later, when work did stall temporarily due to an injury, the contrast became clear. The trust responded immediately, calmly, and predictably. Medical costs were covered, cash flow continued, no requests were needed, no explanations demanded. The trust behaved the same way it always had. From a beneficiary's perspective, that consistency built confidence. She began to understand that trusteeship was not there to indulge success or rescue failure. It was there to hold the middle, to remove extremes, to allow her to think clearly rather than react. That understanding changed her behavior. She stopped asking what she could extract and started thinking about what she wanted to build. She turned down roles that paid well but felt hollow, not because she was protected from consequences, but because she trusted the structure not to punish her for patience. Importantly, the trust didn't lecture, didn't moralize. It simply behaved predictably, and beneficiaries learn fastest from behavior. Years later, she said something that was actually quite revealing. She told me that she rarely thought about the trust at all. Not because it was irrelevant, but because it was reliable. It didn't intrude into her decisions. It didn't compete for attention. It allowed her to focus on her work rather than her finances. That's what good judgment looks like from a beneficiary's side. Not generosity, not restriction, but consistency, restraint, and timing. Trustees often underestimate this to focus on fairness in outcomes. Beneficiaries experience fairness in process, in whether decisions feel thoughtful rather than reactive, in whether yes and no are delivered with the same tone, in whether silence is deliberate or evasive. Judgment is what allows trustees to manage expectations without confrontation and to preserve dignity without promising results. And that is why judgment belongs in any serious discussion about beneficiaries. Because long before disputes arise, beneficiaries are already learning how the trust works simply by watching how it behaves. Now, what are beneficiaries not entitled to? Much conflict arises from assumed rights that do not exist. Beneficiaries are not entitled to dictate trustee decisions, veto distributions, equal treatment in discretionary trusts, or indeed detailed explanations of every decision. They are also not entitled to distributions simply because assets exist. This is where family tension most often emerges. Assets are visible, needs are felt, expectations fall. And over time, expectations harden into perceived rights. But the law does not recognize these perceptions. Trustees must manage them, but they cannot validate them. And this is one of the most difficult aspects of trusteeship. One of the most corrosive misunderstandings in trusts is the belief that fairness means equality. This belief is deeply ingrained. In families, fairness is often shorthand for equal treatment. In trust law, fairness means proper consideration. These are not the same. A discretionary trust is explicitly designed to allow unequal outcomes, different needs, different timing, or different circumstances. When beneficiaries import a family-based notion of fairness into a fiduciary structure, disappointment is almost certainly inevitable. This disappointment often expresses itself as suspicion. Why did they receive more? Why now? Why not me? Trustees who attempt to defend every unequal income in emotional terms usually worsen the problem. The correct response is not justification, but explanation of framework. This is how discretion works. This is why outcomes differ. This is why entitlement does not arise. Beneficiaries who can accept this tend to stabilize. Those who cannot often escalate. It's not a moral judgment. It's a structural. So let's examine how expectations fall. Because expectations rarely arise from the trust deed, they arise from behaviour. Regular distributions, informal assurances, family conversations, silence. A beneficiary who receives support over many years may come to see it as normal. Not guaranteed, of course, but nevertheless expected. When circumstances change and support is reduced or withdrawn, the reaction is often emotional before it is legal. So this is not entitlement in a legal sense, but it is psychological reliance. Trust law does not prohibit reliance, of course, but it does not protect it either. It's also worth noting that expectations are often inherited. A beneficiary may absorb expectations not from trustees, but from other family members. Parents may reassure children informally. Grandparents may speak loosely. Siblings may compare experiences. None of this binds trustees, but all of it does shape the beneficiary mindset. And by the time trustees encounter an expectation, it may have existed for years. This is why early, clear communication matters. Not promises, not forecasts, but explanation. The alternative, silence, just allows assumptions to grow unchecked. Trustees who explain the nature of discretion early, even at the cost of discomfort, often prevent far greater conflict later. This is why consistent trustee behaviour matters so much. Inconsistent generosity creates the greatest risk. Let's look at expectations of family dynamics. Expectations don't exist in a vacuum. They sit within family systems, sibling rivalry, perceived favoritism, unresolved grievances, some stretching back many years. Trusts often become the arena in which these dynamics play out. The trust is sometimes blamed for decisions that are actually about family history, communication failures, or unspoken assumptions. Trustees can't fix family dynamics, but they can avoid amplifying. Clear process helps, certainly. Consistency also helps. Distance helps. But trying to resolve emotional conflict through distributions rarely works. It actually usually entrenches it. There is a further dynamic that deserves explicit attention. Trusts often become repositories for unresolved family issues. A beneficiary who feels overlooked in one area of life may fixate on the trust. A beneficiary who feels insecure may seek reassurance through distributions. A beneficiary who feels powerless at home may seek leverage through legal language. The trust becomes symbolic, not just of wealth, but of recognition, status, and a sense of belonging. Trustees who treat every request purely as a financial decision may miss this underlying context. It doesn't mean trustees should accommodate emotional needs through distributions. It just means that they should understand why certain requests are charged. Understanding does not require agreement, but it does allow trustees to respond calmly rather than defensively. This is one of the skills of experienced trusteeship. Now let's look at what I like to call the trustees' balancing act. Trustees sit at the center of competing pressures. They must exercise discretion properly, manage beneficiary relationships, and protect the trust as an institution. They can't please everybody, and nor should they try. A trustee who focuses on satisfying expectations will eventually fail in their duties. A trustee who focuses on duty, however, while communicating respectfully, is far more likely to preserve the trust. And this distinction is hard for beneficiaries to accept, but essential for trustees to maintain. From the trustee's perspective, the most dangerous beneficiaries are not necessarily the most demanding. They are often the most ambiguous. The beneficiary who oscillates between gratitude and resentment. The beneficiary who frames requests as needs one day and rights the next. The beneficiary who is silent for years and then erupts. Those patterns are predictable. They usually reflect unaddressed expectations rather than sudden grievance. And trustees who track patterns over time rather than reacting to individual requests are better able to manage this risk. This again reinforces the importance of documentation, not just of decisions, but of interactions. Let me give you another practical example from my book Trust on what impartiality looks like when it's tested properly. In 2008, I was asked to step into a situation that had all the ingredients of a slow, inevitable family breakdown. A Hong Kong shipping family, wealthy, international, and long established, had lost its patriarch. What he left behind was not just a large estate, but a family spread across continents, cultures, and temperaments, each carrying a different sense of entitlements and a different sense of grievance. Some beneficiaries were vocal, confident, and very well advised. Others were quiet, distant, and uncomfortable asserting themselves. A few were already briefing lawyers. None had yet exploded, but the air was thick with assumption. Who would receive what? Who had been promised more? Who had sacrificed most? Who deserved recognition? The widow, formidable in presence but deliberately restrained, made one thing clear. She did not want to arbitrate between her children and extended family. She wanted a structure that would outlast emotion. So he settled a discretionary trust. That choice mattered. Fixed entitlements would have frozen assumptions into rights. Discretion created space, but it also placed a heavy burden on the trustee, because discretion without impartiality quickly becomes favoritism in another form. From the outset, pressure arrived unevenly. Certain beneficiaries called frequently, others waited to be asked. Some framed requests as urgent needs, others as moral entitlement. It would have been easy, and indeed human, to respond more readily to the articulate and to the persistent. Impartiality, however, demanded exactly the opposite. Every request was treated through the same process. Consideration was documented. Timing was deliberate. Decisions were explained by reference to principle, not personality. Importantly, silence was sometimes allowed to remain just that, silence. Not every voice needed to be matched in volume. There were moments of tension. A distribution that one beneficiary regarded as modest was seen by another as unfair restraint. A refusal, carefully reasoned, was interpreted by one branch as personal rejection. In those moments, impartiality was not about soothing feelings. It was about consistency. But over time, something shifted. Quieter beneficiaries, for example, began to engage more, reassured that attention did not depend on noise. Louder beneficiaries learned that persistence did not guarantee priority. The family did not become harmonious, but it became manageable. The trust did not promise equality of outcome, it promised fairness of consideration, and that mattered more than any distribution. At one family meeting, after a long and occasionally heated discussion, the widow was asked whether she wished to intervene. She declined gently, with a small shake of her head. The structure was doing its work. The trustee was holding the centre. What this case taught me is that impartiality is not passive, it's active restraint. It requires the trustee to listen carefully without aligning, to decide without posturing, and to accept that fairness often feels uncomfortable to those accustomed to influence. Impartial trusteeship does not eliminate disappointment, but it does prevent decay. And that is often the difference between a trust that endures and one that collapses under the weight of unmanaged expectation. So, what are the key elements when dealing with beneficiaries? Well, they are information, transparency, and silence. Communication with beneficiaries is one of the most delicate aspects of trust administration. Too little communication breeds suspicion. Too much creates argument. Good trustees explain the framework, explain the process, but do not just justify every outcome. Silence, used carefully, can be protective, not an evasive kind of silence, but principled restraint. Beneficiaries are not entitled to participate in decision-making, but they are entitled to know that decision-making is happening properly. And in that vein, I'd like to talk a little bit about the importance of educating beneficiaries and educating them early. One of the most effective risk management tools in trust administration is early education. Not technical education, conceptual education, helping beneficiaries understand what a trust is, what discretion means, and why uncertainty is part of the design. This is particularly important for younger beneficiaries. Surprise is rarely helpful, and a trust explained early tends to be respected later. A trust revealed suddenly, on the other hand, often becomes a source of shock and resentment. Education does not eliminate disappointment, but it certainly does contextualize. Education is not a single event either. It's a process. A short explanation at age 18 will not hold at 35, nor will it hold at 50. Because as beneficiaries mature, their questions inevitably change too. Early education should focus on what a trust is, why discretion exists, and what uncertainty means. Later education should focus on governance, long-term stewardship, and responsibility. Trusts that invest in this layered understanding tend to produce beneficiaries who are less reactive and more effective. It's not about creating compliance. It's about creating context. One of the most difficult transitions in trust administration occurs silently. It's the moment when a beneficiary stops seeing the trust as something abstract and starts seeing it as something personal. This usually coincides with adulthood. Not legal adulthood, but psychological adulthood. The point at which the beneficiary begins to make independent life decisions and measures those decisions against the existence of the trust. At this stage, the trust often becomes more emotionally charged, not less. As children, beneficiaries tend to accept explanation. As adults, they begin to test boundaries. They ask different questions. Not, what is this trust, but what does it mean for me? This shift matters enormously because the trust may not have changed, but the beneficiary's relationship to it has. Many trustees underestimate this phase. They assume that early education, once delivered, will hold. It all too rarely does. Adult beneficiaries reinterpret earlier explanations through a new lens. Support, once seen as generosity, may now be seen as obligation. Discretion, once seen as protector, may now be seen as arbitrary. Silence, once seen as benign, may now be read as exclusion. None of this alters the legal position, of course, but it does alter the emotional climate in which trustees must operate. This is often the point at which beneficiaries begin to compare, not just between siblings, but between themselves and peers, friends who inherited outright, colleagues who received family business shares, partners whose families operate differently. The trust becomes a reference point, not just financially, but psychologically. Trustees who do not recognize this shift often misinterpret what follows. They assume that requests are purely financial. They assume that frustration is just about money. Often it's actually about recognition, about being taken seriously as an adult participant in the structure, even if not as a decision maker. This is where trustees must exercise a different skill, not legal analysis, but a kind of calibration. The beneficiary does not gain new rights at this stage, but they often do expect a different relationship. Where trustees fail to adjust communication, escalation becomes more likely. Where trustees adjust tone without adjusting boundaries, discretion erodes. The balance is delicate, and it must be handled consciously. Adult beneficiaries do not need control, but they do need coherence. They need to understand how discretion operates now, not how it was explained 10 years ago. They need to see that trustees are engaging with their circumstances, even when the answer is no. They need to see that the trust is not something that's simply frozen in time. Trustees who restate principles without context often sound dismissive. Trustees who contextualize principles without conceding authority tend to retain legitimacy. There's also a difficult truth that must be acknowledged. Some beneficiaries reach adulthood without developing responsibility in parallel. Age and maturity diverge. Trusts expose this divergence. Where outright inheritance might disguise it temporarily, discretion brings it into sharp focus. This is uncomfortable for beneficiaries, but also for trustees, and often for settlers, if they're still alive. Trustees must resist the temptation to compensate for immaturity with generosity. That rarely produces growth. It usually actually entrenches dependency. Equally, however, trustees must resist the opposite temptation, to become rigid, procedural, or emotionally distant in response to frustration. That escalates conflict unnecessarily. The trust is not a test that the beneficiary must pass, but neither is it a safety net without consequence. The purpose of discretion at this stage is not punishment or reward, it's alignment. Alignment between support and responsibility, between assistance and agency. Trustees who understand this tend to think in trajectories rather than transactions. They ask, what behavior are we reinforcing over time? What expectations are we setting for the next decade, not the next request? What kind of adult relationship are we modeling between the trust and the beneficiary? This long view thinking is one of the quiet marks of competent trusteeship. It's also one of the least visible. Beneficiaries rarely notice when it's done well, but they do notice when it's absent. There's also a structural point worth making. Trusts that anticipate this phase explicitly tend to weather it better. Those that do not often experience a sharp increase in friction at precisely this stage. This is why some trusts include staged communication, not staged entitlement, but staged explanation. Early focus on what a trust is, later focus on how discretion is exercised, later still focus on stewardship, longevity, and collective responsibility. It's not indulgent, it's pragmatic. The reason is that beneficiaries who understand the trust as an institution behave differently from those who see it as a gatekeeper. Institutions invite engagement, gatekeepers invite challenge. The difference lies largely in how trustees manage this transition, not legally, but relationally. Handled well, this phase strengthens the trust. Handled poorly, it's often the beginning of dispute. There is a further complication at this stage that trustees often encounter but rarely name: adult beneficiaries begin to test not just outcomes, but process. They pay closer attention to how decisions are made, who is consulted, who is not, how long decisions take, what language is used. Tone becomes evidence, delay becomes meaning, and silence becomes interpretation. Trustees who are used to operating quietly may find this uncomfortable. What once felt like an appropriate distance is now experienced by the beneficiary as opacity. What once felt like neutrality is now read as avoidance. Now, of course, this doesn't mean that trustees should open their deliberations or invite participation in decision making. That would be a mistake. But it does mean that trustees must be intentional about how process is communicated. Explaining that a decision has been considered properly is often more important than explaining why a particular outcome was reached. Adult beneficiaries are often less focused on agreement than on legitimacy. They want to know that the system they are subject to is real, coherent, and applied consistently. When trustees fail to demonstrate that, beneficiaries begin to personalize outcomes. The trust becomes less an institution and more a relationship. And relationships invite negotiation, pressure, and emotional escalation. This is where trustees can inadvertently weaken their own position, not by being wrong, but by being unclear. The discipline required here is subtle. Trustees must remain firm on authority whilst becoming clearer on process. They must resist debate about entitlement while being explicit about governance. They must show engagement without offering influence. This is all very difficult. But trustees who manage it well often find that beneficiary behaviour stabilizes over time. Those who avoid it usually find that challenge, once started, rarely reverses itself. At this stage, clarity is not concession, it's protection. So, what happens when beneficiaries challenge trustees? Well, challenges usually arise when expectations are disappointed, communication breaks down, or trustees appear inconsistent. Most disputes begin informally. Requests become demands, demands become accusations. By the time lawyers are involved, positions are often incredibly entrenched. Trustees who have documented their reasoning, applied process consistently, and avoided informal commitments are far better protected. Beneficiaries who understand their true rights are less likely to escalate. Now, as we close this episode, let's draw some central lessons together. What have we learned? First, the beneficiary is someone within the defined objects of a trust, not someone who hopes to receive something. Second, that in discretionary trusts, beneficiaries have rights of consideration, not rights of entitlement. Past distributions do not create future guarantees. Third, that fairness in trust law doesn't mean equality of outcome. It means proper and impartial consideration within the framework of the deed. Fourth, the core beneficiary rights exist to ensure accountability. The right to proper administration, to proper consideration, to enforce the trust, and to appropriate information are safeguards, not levers of control. Fifth, that expectations form behaviorally, not legally. Regular generosity, informal assurances, and silence shape perception far more powerfully than drafting. Sixth, that family dynamics often attach themselves to the trust. Trustees cannot resolve sibling rivalry or historic grievance, but they can avoid amplifying it through inconsistency. Seventh, that impartiality is active restraint. Treating loud and quiet beneficiaries through the same discipline process preserves legitimacy over time. Eighth, that communication must explain framework and process without inviting negotiation. Too little breeds suspicion, too much invites argument. Ninth, that beneficiary understanding must evolve. Education is not a single explanation, but a staged process as beneficiaries mature and reinterpret their position. 10th, that most disputes arise when expectations harden into assumed rights. And finally, that beneficiaries are central to a trust, but they're not its owners. Confusing eligibility with entitlement is one of the most common and destabilizing misunderstandings in long-term structures. In short, trusts remain stable not simply because the law is clear, but because beneficiaries understand the difference between what they may receive and what they never owned. And that was Beneficiaries, Unpacked. Join me in the next episode, number 11 of our series of 20, and the first of our group covering decision-making, governance, and administration of trusts to unpack the trustee decision-making process. Until then, I am Alexander von der Ven.